Hi everyone, and welcome back to the Flow Migration Law channel. My name's Jay. The journey to an Australian partner visa is usually a marathon. It takes careful planning and months of preparation. But what happens when unforeseen circumstances turn that marathon into an all-out sprint? Today, I want to walk you through a real case we handled where a couple had just 2 weeks to lodge a complete partner visa application before visa expired. It's a story about a race against time. And it highlights just how critical a methodical approach is when your future together in Australia is on the line. So let me set the scene. We were approached by a lovely couple. The applicant, a lady from Thailand, had been in Australia for several years. First on a student visa, then a graduate visa, and most recently, a medical treatment visa for a specific procedure. During her time here, she met her Australian partner. They had a strong, committed relationship for over a year, deeply rooted in their shared religious community. They knew about the 4 pillars of a genuine relationship and were slowly gathering their evidence. Everything seemed to be heading in the right direction. But here is where the massive hurdle appeared. Due to their deeply held religious beliefs, they could not live together until they were officially married. Their wedding was all planned, which was wonderful, but the date was set just 2 weeks before the lady's medical treatment visa was due to expire. They came to us only a few days before the wedding. This left us with an incredibly narrow 14-day window from the wedding day to prepare and lodge one of the most document-heavy visa applications in Australia. We had to gather financial evidence, social evidence, detailed personal statements, and statements from all their friends and family, all within that tiny time frame. There was absolutely no time to waste. We immediately sat down with the couple and created a very clear, structured roadmap. In a situation like this, prioritization is everything. First, we focused on securing the non-negotiable documents needed for a valid lodgement. Things like identity documents and of course the official marriage certificate the moment it became available. Next, we guided them on how to write their personal relationship statements efficiently, making sure they covered their entire history. At the same time, we provided clear instructions to their family and friends on how to complete their supporting statements quickly and efficiently. Every single document they sent us was reviewed in real time. There was no room for back and forth that would waste precious days. Through that intense collaborative 2 weeks, we successfully lodged their complete partner visa application just before the deadline. This meant the client's lawful status in Australia was secure. She was granted a bridging visa A or BVA, which came with full work rights. They could finally breathe and continue their life together without that immediate threat of separation. And I'm very pleased to say that their visa was ultimately approved. But what if they had missed that deadline by just 1 day? This is really important. She would have become unlawful. Lodging after her visa expired would have meant getting a bridging visa C, which does not come with automatic work rights. Even more critically, it would have triggered what's known as Schedule 3 criteria. Schedule 3 is a legislative barrier that is notoriously difficult to overcome. You have to prove compelling and compassionate reasons for being unlawful, and simply not being married in time is highly unlikely to be accepted. A failure to meet Schedule 3 would have led to a visa refusal, no matter how genuine their relationship was. So what can we learn from this? First, preparation can start much earlier. The couple thought they could do nothing until after they were married, but they could have prepared almost everything else well in advance, making those final weeks much calmer. Second, understanding the timing of your application is just as vital as knowing what documents you need. Getting advice early can completely change the journey. And third, when time is short, the risk of making a mistake is high. With partner visa application fees being what they are, a simple mistake made under pressure is an incredibly expensive one. Getting it right the first time is very important. Navigating an urgent and complex visa application requires a calm, methodical, and experienced hand. This couple's story had a positive ending because we were able to implement a precise strategy under extreme pressure. If you find yourself facing a complex or time-sensitive visa situation, having a clear path forward is really important. My name's Jay Son, and the principal lawyer here. I have over 8 years of dedicated experience working solely in Australian migration law, helping people navigate these intricate processes. To discuss the specifics of your own case and map out a strategy, the best way to get in touch is to reach out directly by emailing me at js@flowmigrationlaw.com.au to arrange a consultation. Thank you so much for watching. If you found this case study helpful, please give the video a thumbs up and subscribe for more insights into Australian migration law. We'll see you in the next one.